Looking at lease extensions, there are broadly speaking two ways to go about extending the lease length. There is what's known as the voluntary or informal route, which is where you agree with the freeholder how much the lease will be extended by, how much that will cost, and what happens with the ground rent. Or there is the statutory route, which requires the service of a Section 42 notice. So this is also known as the formal route. And this is where, as of right, you are entitled to 90 additional years and to remove the ground rent entirely for the rest of the term. There are some important distinctions between the two. On the voluntary route, it can be quicker and terms can be more or less negotiated between the parties as they see fit. However, there can be the risk that sometimes the communications can break down, and as is often the case, the leaseholder will be required to actually put funds up front for the freeholder's legal costs and valuation costs, which can be a risk if the process falls apart. If you contrast this with the Section 42 route, the formal route, this is the one whereby once the notice is served, you know that the freeholder has to reply within 2 months. And then after that point, there are a series of deadlines that must be met that are prescribed by law. So it does remove some of the risk of the process breaking down and grinding to a halt, although often you need to weigh up the pros and cons of both processes, and perhaps if the relationship with the freeholder is one that's not particularly close or friendly, I would always suggest the statutory route to simply start the process and know that there will be an end point in the future that isn't dependent upon fairness or the freeholder acting promptly.